Good afternoon, everyone. Thank you so much for joining us today. My name is Carrie Chin, and I am a Wellness Program Administrator here with Healthy County in the Health Benefit Services Department. And we're excited to kick off the webinar today. This video is presented by the Texas Association of Counties in collaboration with Groom Law to provide information for educational purposes only about the Health Insurance Portability and Accountability Act, referred to as HIPAA. Presenting this information is Christy, who is principal at Groom Law Group. As a reminder, TAC is limited in what information is disclosed to counties and districts, as this information is considered protected health information, or PHI, under HIPAA. For example, when counties and districts request information about which individuals completed a wellness program offered by Healthy County, that information would be PHI. TAC cannot disclose PHI to the counties or districts unless, 1, the individual provides their HIPAA authorization, or 2, the county/district is acting in its plan sponsor capacity and signs a plan sponsor certification that it will comply with HIPAA. Since counties and districts have asked for more information about the content of the plan sponsor certification and HIPAA requirements in general, this is a HIPAA educational only video. This is not a formal HIPAA training, but a high-level overview of HIPAA, including an explanation of the plan sponsor certification. And as a disclaimer, TAC is providing this HIPAA webinar as an educational resource only. Each county and district has its own HIPAA responsibilities, including localized HIPAA training with respect to any health plans they sponsor. Counties and districts should consult their own county/district attorney or outside counsel regarding specific actions they should or should not take. The facts of each county or district's benefits plan and structure may differ from the examples in this video. Neither this video nor TAC is providing legal advice. Okay, and with that, I'm happy to hand it over to our host today, Christy with Groom Law Group. Thanks, Christy.
Thanks, Carrie. Well, I'm going to jump right in. Today, we're going to be covering HIPAA basics. So first of all, an overview of the HIPAA box, what entities are in the HIPAA box, what information is in the HIPAA box. Then we're going to talk about use and disclosure of protected health information, or PHI, when we're able to disclose information outside of the HIPAA box. We're going to drill down in particular, as Carrie mentioned, on the plan sponsor certification. So that's the certification that the districts or counties that sponsor the TAC health plans would need in order to access PHI. Then go through 5 red flags that you may want to keep in mind. And then I'm going to end with, if you only remember one thing from today. So a little teaser to stay to the end if you only remember one thing from today. So we'll kick it off with the HIPAA box. A HIPAA overview. HIPAA has 2 rules we're talking about today. The HIPAA privacy rules govern the confidentiality of protected health information, and the security standards govern the security or the cybersecurity of electronic, or ePHI. HIPAA is enforced by the U.S. Department of Health and Human Services, HHS. And if you work in this area, or you're going to be receiving PHI on behalf of your county or district, then you might want to take a look at the HHS website for HIPAA. I have the link here, and they have really great guidance there. There's summaries, there's Q&As. It's a really good resource if you're working with HIPAA. So the HIPAA box, what is the HIPAA box? Now, this is something you won't find actually in HIPAA. I made up this term, the HIPAA box, because it helps me envision when information and when entities are subject to HIPAA inside the box have HIPAA requirements and when they don't. So I'm going to talk about the HIPAA box throughout here, and we're going to talk about what entities are in the HIPAA box and what information is inside the HIPAA box. So what entities are inside? HIPAA covered entities. That's the term used in HIPAA of the entities that are directly subject to HIPAA. And the HIPAA covered entities are health plans, healthcare providers, and clearinghouses. So taking that a little backwards, clearinghouses are entities that transfer information from health plans to healthcare providers in electronic format. We're not going to talk about that today. That's outside of our scope here. Healthcare providers are doctors and hospitals and those that provide treatment services, also outside of our scope here. We're going to focus on health plans because that's why we're here. We're here talking about the TAC health plans. And a health plan under HIPAA can be a self-funded plan, an insured plan, a group plan, an individual plan, a governmental plan, Medicare. All of those are health plan covered entities under HIPAA, as long as they are paying or providing for medical care. And there's a really broad definition of medical care under HIPAA that includes prevention and any function or structure of the body. If we have a benefit that's paying or providing for medical care, then it's going to be a health plan subject to HIPAA. So for example, medical plans, dental, vision, prescription drug, health flexible savings accounts, employee assistance programs, those are all entities that would be considered health plans and they're HIPAA covered entities. Disability, life, pension plans, those are not plans that are considered to be paying or providing for medical care. So they're not in the box. They're not subject to HIPAA. They're outside the box. Now, wellness programs, we're talking about wellness in particular today. They can be something that's a health plan, paying or providing for medical care. They're providing prevention services or maybe blood work, something that has to be administered by a trained healthcare professional or a nurse. They could be considered to be providing medical care. And so they would be health plans inside the HIPAA box. It would really depend on the facts of what the wellness program has. Also inside the HIPAA box are business associates. So these are the vendors that work for health plans. They're not doing it by themselves. They hire service providers as well. So third-party administrators, wellness vendors, lawyers, accountants, consultants, anyone who's receiving PHI on behalf of the health plan or the provider is a business associate. They are also required to comply with HIPAA. And the health plan, the TAC plan here, has to have a business associate agreement or a BAA with those service providers, with that business associate that requires that business associate also to comply with HIPAA. So we have the health plan inside the box, HIPAA box, and we have the business associate inside the HIPAA box. What about employers and employer information? So as a county or a district, you're an employer. The employer is outside the HIPAA box. Sometimes that surprises employers. So we have under HIPAA, the health plan is a different entity than the employer. They're two separate entities. The health plan is inside the box, but the employer is not. So employers have access to all kinds of health information in their employer capacity, sick leave, ADA requests, but those are not subject to HIPAA. They're outside of the HIPAA box. Now, a question I get a lot of times is about enrollment information. So enrollment information is usually held, at least at the beginning, and by the employer in its employer capacity. And PHI under HIPAA does not apply to information held by the employer in its employer capacity. So the employer is doing annual enrollment for a lot of different benefits, the health plan, medical benefits, but also maybe the disability and life and retirement plan benefits. At that point, it's holding that information in its employer capacity outside the HIPAA box. So the employer has that information and it's not subject to HIPAA. But at some point, the employer is going to send an eligibility feed to the health plan, to the TAC plans, or whatever other health plans you might have. And at that point, it goes inside the HIPAA box. It becomes PHI, even if it's disclosed back outside the HIPAA box. So as an employer, it's important for us to know who's in the HIPAA box, who's not, when the employer is outside of the HIPAA box, because then you might have other privacy rules you have to comply with, but not HIPAA, but then be able to recognize when something goes into the HIPAA box and when it comes back out, because then HIPAA will apply. So I keep talking about protected health information, or PHI. That is the information inside the HIPAA box. HIPAA applies to PHI held by a covered entity or a business associate, so by the health plan or by its business associates, and it includes any individually identifiable health information, even if the names have been removed. So even if it's just a list of names and their addresses, demographic type information, that is still considered PHI when it's held by the health plan or the business associate. It doesn't matter if it's electronic information or paper information, it's still going to be PHI if it's held by the health plan or the business associate. So some examples, a list of enrollees is considered PHI when held by the health plan. The claims reports, appeals information, emails about medical claims, a list of wellness program participants, all of that would be PHI held by the health plan inside the box. So we know inside the box, we have the covered entity, the health plan, we have the business associate of the health plan, and we have PHI. So what is not PHI, not inside the HIPAA box? De-identified information. And that's the term used under HIPAA. Sometimes I have clients that say, oh, it's just aggregate. We took out their names. There's nothing left. There's no claims information. It's aggregate information. That's not a term under HIPAA. It's either PHI or it's de-identified. Those are the only two buckets we have under HIPAA. So if information is held by the health plan or the covered entity or the business associate who has come from the health plan, it's going to be PHI unless we de-identify that information under one of two methods that are allowed by HIPAA. An expert method, that's where we're hiring, or the health plan is going to hire someone to make a determination that this information is not identifiable. Or the most common one I see is a safe harbor method. That's where the health plan has to remove 17 different identifiers, including dates, geographic identifiers, ID numbers, names, and not have any actual knowledge that the information left could be used to identify someone, even if combined with outside information. So I've listed here all the identifiers that would need to be removed to create de-identified information, because this is an area I get a lot of questions in, and I think a lot of groups are well-intentioned and think they're using de-identified information or aggregate information and HIPAA doesn't apply, or they're not asking for PHI, but they really are asking for PHI unless all of these identifiers have been removed. The ones that seem to be the hardest: names, geographic identifiers smaller than a state, and dates, birth dates, admission dates, discharge dates, prescription fill dates, that type of thing. So all of these identifiers would need to be removed to create de-identified information, and we'd have to have no actual knowledge that whatever's left could be used when combined with other information to identify someone. If information really is de-identified, it's no longer PHI, it's not inside the HIPAA box, and HIPAA wouldn't apply. So I have a real life scenario here for us here. The TAC health plans are inside the HIPAA box. You can see there's a box there, a red line around it, because they're a health plan. They're inside the HIPAA box. They're a HIPAA covered entity. Well, the counties and the districts are an employer that sponsors those health plans for its own employees. They're outside the HIPAA box. You see there on the side. So when the county or district is acting in its employer capacity and holding information like a sick leave or enrollment information or payroll information that it did not get from a health plan, just holding that information in its employer capacity outside the HIPAA box, not subject to HIPAA. And we're going to talk about when there's some interaction there, though, when PHI might get shared outside the HIPAA box to the county in the plan sponsor capacity. We're going to get to that next. All right, so HIPAA basics here. We've talked through who's inside the HIPAA box and what information's inside the HIPAA box. But now we're going to talk about how information can be disclosed outside the HIPAA box. So under HIPAA, the general rule, the default rule, is that the health plan has to obtain the individual's HIPAA authorization to use or disclose their PHI. Not the plan sponsor's authorization, not the employer's authorization, the individual's HIPAA authorization to use or disclose their PHI. That's the default rule. The authorization has to be in writing, has to be signed, it has to be standalone, can't be combined with other types of authorizations or consents, and has certain content that it has to have. And it also has to be voluntary. But there are some exceptions. The biggest exception is that a health plan is permitted to use or disclose PHI for treatment, payment, or healthcare operations purposes. Sometimes we call that TPO. So treatment, that's what you would think a provider is treating someone. So the provider is able to use or disclose PHI for that purpose. Payment of claims. The health plan's using or disclosing PHI to pay the provider for the claims that the individual filed or pay the individual. Healthcare operations, that can include things like evaluating health plan performance, fraud detection, legal questions, care coordination, case management, things that are more the administrative types, routine things that a health plan would do. So claims payment, eligibility determinations, coordination of benefits, fraud detection, those types of things fall under the routine treatment, payment, or healthcare operations, the everyday types of things that a health plan would do. Those are permitted. We don't need authorization for those. And there are specific definitions for what treatment, payment, and healthcare operations entails. So we look in those definitions to see, okay, this is something that the health plan is permitted to disclose or use, even without the individual's HIPAA authorization. There are also some other limited exceptions that are not automatic, like treatment, payment, healthcare operations. They apply on the particular they apply depending on the particular facts. So sometimes it might be required by law for have a disclosure. There might be an audit, so there's a health care oversight exception. There's a law enforcement exception, a subpoena exception. But each of those exceptions have their own facts, and there are requirements for each of those exceptions the health plan has to look at. So these are really one-off type of exceptions. We're also able to disclose PHI without an authorization if information is de-identified under the standard I talked about before. And then the health plan is also able to disclose PHI to the individual if it's the individual's own PHI. But there's a caveat there. Each individual under HIPAA, so everybody listening to this with respect to your own health plan, with respect to your own healthcare provider, is permitted to, it has a right to their own PHI. But you don't automatically have a right to your family member's PHI. Each person has a right to their own PHI. So before a health plan or a provider can disclose PHI to a family member, they have to consider, is this someone who would, if it's not the individual themselves, is this someone who can act for the individual under applicable state law? So a parent of a minor child usually can act for an individual, and also someone with the power of attorney can act for an individual. So it may be permissible to disclose to that person automatically. But generally, if it's a disclosure to a family member, we would need to have the individual's HIPAA authorization. Disclosures to the employer plan sponsor. That's where you all come in, the county and the district. So there might be good reasons, and HIPAA's recognized this, that the employer plan sponsor might want to access some PHI from inside the box from the health plan. So there are 3 methods that the health plan can use to disclose PHI to the employer plan sponsor. If it's just enrollment information, just who's enrolled or disenrolled, the health plan can disclose that. If it's summary health information, and that's information that's de-identified with certain geographic identifiers added back. So still very high level information, almost de-identified. The health plan can disclose that to the plan sponsor if the plan sponsor needs it for underwriting purposes or to modify the plan. And then the one we're talking about today, plan administration functions. The health plan can disclose PHI to the plan sponsor if the plan sponsor certifies that it will safeguard the PHI and only use for a plan purpose under the plan sponsor certification. And we're going to dig into what that means. So that's where you all have come in, because you all, the counties and districts, have signed a plan sponsor certification in order to receive any PHI from the TAC plans. HIPAA also has individual rights where we all have rights to our own PHI and certain rights to that with our healthcare providers, with our health plans. We have a right to access our own PHI, to get a copy of our PHI. We have a right to amend our PHI. This is usually for the providers, not the plans, but if I disagree with my medical record, I can ask for it to be amended. Now, my provider or my plan doesn't have to do that. If they think the information is correct, they don't have to amend it, but they have to note that I disagreed. I have a right to an accounting of PHI disclosures. So the provider and the health plan have to keep track of all the disclosures they've made that are outside of treatment, payment, healthcare operations, and make a list of those, and I have a right to request that list. I have a right to restrict my PHI. I can ask that my PHI not be used for certain purposes. The health plan or provider doesn't have to agree, but I have a right to request it. And I have a right to request confidential communications. I can ask for my information to be sent to an alternate address. And the health plan or the provider has to agree if I say I would be in danger from wherever the information was being sent already. That would come up typically in a domestic violence type situation where I want my information to go to my explanations of benefits or my treatment records to go to a different address. There's also HIPAA security standards. So I've been talking about the HIPAA privacy rules, which apply to the confidentiality of protected health information, how information can be used and disclosed. But there's a whole nother set of rules on HIPAA security, cybersecurity. And it's the security rules. There's about 55 standards, and they're listed in 3 buckets: administrative, physical, and technical safeguards. And these are the kinds of safeguards that you probably would envision that a health plan or provider you'd want them to keep your information safe, your electronic protected health information. Password protection, have a disaster recovery plan, have workstation security or facility access controls to the places the computers are that have the information. Automatic log off, authentication to make sure whoever is trying to access PHI is the right person who they say they are, encryption. So we have the privacy rules and we have the security standards. And so the health plan and the business associates are required to comply with both of those. We also have breach rules. Now, all of us receive notifications, I'm sure, if you're like me, all the time from different entities that say, oh, there might have been a possible breach. Well, for PHI under HIPAA, we have our own set of breach rules. So if there is a privacy or security breach, whether it's paper or electronic, whether it's intentional or accidental, if there is a breach of PHI, it may be something that the health plan has to report. And there are 4 factors that the health plan would consider to decide if information at PHI has been compromised: the type of PHI, the unauthorized party that accessed the PHI. Was it someone who works for the plan and they just didn't have access to that information? That's who saw it. Was it a bad actor who hacked into the system? Whether PHI was actually acquired or viewed, and the extent to which risk has been mitigated. So the health plan would have to consider those factors and decide, is this a reportable breach? And if it is, they may need to notify the individuals, the media, HHS, the Department of Health and Human Services, within 60 days of discovery. Also may need to report to the state. So there's a requirement to go through to gather the facts of a breach, but there are factors that have to be applied, reporting that has to be made, and then a decision of how to report. Now, sometimes the breach is not on the part of the health plan itself. Usually it's on the part of a business associate. So the business associate has to notify the health plan, and then the health plan would have to decide if they have a reportable breach. So another real life scenario here. The county is requesting wellness data. That's why we're here. We're getting some education here about HIPAA basics, and particularly in the wellness area. So the TAC Health Plan administers wellness programs, and those wellness programs are PHI. That's individually identifiable health information, so it's inside the HIPAA box. Even a list of people who participated in a wellness program is considered PHI. Because remember, I said a list of enrollees, when held by the health plan, is considered PHI. So if a county is requesting that information about who's participated in a wellness program, it's requesting PHI. And the TAC health plan is inside the box. And I showed you before, the counties are outside the box, the county and the district that sponsors the plan. So they can only, the TAC health plan can only disclose PHI if the individual has signed a HIPAA authorization, or the county has signed a plan sponsor certification that says the county only will use this information for a plan administration function. Because remember, I talked about there are 3 ways that the health plan can disclose PHI to the plan sponsor, and the plan sponsor certification was one of those ways. So either we have an individual's HIPAA authorization to disclose, the TAC plan would get that authorization to disclose to the counties, or the county would sign a plan sponsor certification. And that is typically, I think, what we see. So what exactly does that mean, and what is in this plan sponsor certification? I say this is a section that's also known as when to wear your HIPAA hat. We're going to be talking a lot about in this section what the HIPAA hat is and how you know you're wearing it. So the plan sponsor certification that the county or district has to sign if it wants to access PHI from the TAC plans require, first of all, that the county or district designate which employees can have access to PHI. We need to be specific. It can't just be where it comes into the county and hopefully somebody recognizes this as PHI. We need to know who's going to be our HIPAA designated staff who are able to access PHI, because we want them to be able to recognize PHI, be trained on how they can use PHI, and know when it's okay to disclose it. So if they're wearing their HIPAA hat because they're a HIPAA designated staff, they can only use PHI for health plan administration functions for the health plan, not for any employment action, not for purposes of the county otherwise, not for purposes of other benefit plans sponsored by the county. It needs to be for a health plan purpose. And we're going to talk a little bit more about what all that means. Also, the certification says that the county or district is going to require any subcontractors to comply with the certification too. So if there are any vendors from the county that are going to access that PHI, they have to agree to the same terms. The county or district also has to report to the TAC plan any HIPAA violation or breach. If information's been breached or there's been a violation, we've shared it with the wrong person, we have to let the TAC plan know. The county or district has to make sure that it's able to disclose its internal practices or procedures to the Secretary of HHS upon request. So if HHS is auditing the TAC plan, and the TAC plan is disclosed PHI to a county, then the Secretary of HHS may also ask for some records from the county as well to make sure that you're complying. We also have to, the county or district, comply with whatever those individual rights are that I talked about. So if someone requests their PHI or access or disclosures from the TAC plan, it may be the TAC plan would look to the county or district to say, okay, what information do you have? What disclosures have you made? So we have to assist the TAC plan if there's any of those types of requests. Under the plan sponsor certification, the county or district also has to have a process to resolve issues of noncompliance. So if it turns out that whoever we've designated in our HIPAA designated staff, they're not complying, we may need to retrain, or we may have to remove their access, and we need to have some type of process for that. The county or district also has to destroy or return any PHI when it's no longer needed, return it to the TAC plan. So if you're using PHI for a certain purpose and you no longer need it, then the requirement under the certification is to return or destroy it. If it's not feasible to return or destroy it, so maybe we have a legal requirement to hold that data for a certain amount of time for auditing purposes, then we can only use it for that purpose and have to continue to comply with HIPAA and the certification as long as we hold any PHI. Under the plan sponsor certification, the county or district also has to have security safeguards in place. Those same cybersecurity standards that I talked about that apply to the health plan also would apply to the county or district. We need to have strong cybersecurity for electronic PHI, and require our subcontractors who access ePHI to have strong security standards too. We also have to report any security incidents of ePHI to the TAC plan. And finally, we have to firewall off PHI from non-PHI. So if the counties or district is receiving PHI, it can't commingle that PHI with non-PHI. It has to firewall it off and keep that PHI secure and comply with HIPAA with respect to that PHI. So that may mean we have keep all the PHI in a password protected file or in a separate drive that has encryption or some way that only those people who are in the HIPAA designated staff are able to access that PHI. And they would know that they can't commingle the PHI with other information or use it for a non-planned purpose. All right, so we have gone through the HIPAA box. We've gone through the HIPAA box, what entities are in the HIPAA box, what is PHI, what are some HIPAA basics of when PHI can be used and disclosed outside of the HIPAA box, what are some of the other requirements under HIPAA. We have drilled down on the plan sponsor certification. So if the county or the district is asking for PHI from the TAC plan, from a health plan, signs the plan's sponsor certification to be able to receive PHI, what its responsibilities are. We've gone through all that. But I want to point out 5 red flags. Now, these are questions and issues that I typically see, and I thought hard about what my 5 red flags were, because these are areas that I can see some pitfalls or issues in real life, like with plans and with plan sponsors that I've worked with. So I want you to learn from the experience of the groups I've worked with before and be on the particular lookout for these 5 red flags. So first of all, red flag number 1, who may view PHI? The plan sponsor certification requires the county or district to designate which county employees may access PHI. So like I said, we need to assign who's in our HIPAA designated staff, and we need to be specific about it. They need to know that they have their HIPAA hat on, that they're responsible for the PHI. They need to know who's not in the HIPAA staff, the designated staff, so we know where PHI can go, and we know who's not wearing a HIPAA hat, who should not be able to access PHI. For those who are HIPAA designated staff, they should have HIPAA training so they understand the HIPAA restrictions, and they should be able to recognize PHI when it comes in. They may be receiving lots of different information, some health-related information held by the employer in its employer capacity, sick leave information. They may receive information from the health plan. So they need to be able to recognize when they have PHI, when they don't. And then they need to know when they're wearing their HIPAA hat and what that means, what their restrictions are on how they use that PHI. The HIPAA designated staff should safeguard PHI under those rules that are in the certification and not share with employees who are not in the designated HIPAA staff. So that's our first red flag. Our second red flag, when may PHI be used or disclosed? So the staff who are HIPAA designated can only use or disclose PHI for plan administration functions. That's what our plan sponsor certification said. Can only be used for purposes of the health plan. The HIPAA designated staff is not permitted to use PHI for other county or district purposes. That's not for the health plan, for employment actions, or they can't disclose PHI for other types of county district employee benefits. So we have to have that firewall around the PHI so that it's only being used for health plan purposes. But what exactly does that mean? So I have an example here that walks through some scenarios. Longhorn County has requested that the TAC Health Plan send a list of county employees who have completed the TAC Health Plan's wellness program. This list is considered PHI because it has individually identifiable health information held by the TAC Health Plan. The TAC Health Plan requires that Longhorn County sign a HIPAA plan sponsor certification in order to disclose this PHI. Longhorn County signs the plan sponsor certification and determines who is part of its HIPAA designated staff. So far, so good. We know the wellness information is PHI held by the health plan. Health plan can't disclose it to the plan sponsor unless the plan sponsor signs the plan sponsor certification, or we have the individual's HIPAA authorization. Here, the Longhorn County has signed the HIPAA plan sponsor certification, and they've designated their HIPAA staff, so they know who is able to receive PHI. But how can Longhorn County HIPAA designated staff use or disclose this PHI? We have the procedure set up to make sure only people who should have access, but what can they do? So how can Longhorn County HIPAA designated staff use or disclose this PHI? And I have 4 examples. First of all, to evaluate TAC health plan performance or to consider health plan related questions. Yes, that is a health plan purpose. If the county is using this information to evaluate health plan performance, look at health plan related questions, that would be something that's for purposes of the health plan, something they would be permitted to do. To administer or provide additional incentives to participate in the TAC health plan's wellness program. So if it's where the county is asking for this information because someone's completed the wellness program and they need to facilitate the incentives with payroll, that's a health plan function. If the county is providing additional incentives to say we want to add a little bit more here to encourage people to complete their wellness program, that probably is something that would be a health plan purpose. But, and I didn't say yes here, I said maybe a health plan purpose because there's a lot of different facts we'd have to consider. This is an area where you're going to probably want to run this by your county or district attorney or your outside counsel because it could be pretty fact specific. So we want to make sure if it's for a health plan purpose, if we're using this information. To create a leaderboard that will be posted on the employee intranet showing which employees have earned the most incentives. So that would not be for a health plan purpose itself. In that case, we would be disclosing someone's individual name outside of the health plan, or not for a health plan purpose. We would be disclosing their own PHI. We would need the employee's HIPAA authorization in that case. To send a list of non-participants to each employee's manager so the manager can encourage those employees to do better, or else there will be consequences. Well, that would not be for a health plan purpose. That would be for an employment purpose and not be permitted. So we need to keep in mind who is able to receive PHI. They have their HIPAA hat on. Then they need to consider what the reason that they're going to use or disclose PHI, make sure it's for a health plan purpose. And like I said, it's a good idea to run it by your county or district attorney because these can be pretty fact-specific scenarios. Also, there could be employment law issues, particularly if we're disclosing someone's name, we're potentially using something that could be considered an employment issue. So we want even more reason to consult the county or district attorney. So red flag number 3. For those multitaskers. So usually anyone who's receiving PHI for the plan sponsor, that's not their only job. They have lots of different things they're doing. Sometimes they're acting on behalf of the employer in its employer capacity, handling sick leave and OSHA requests and maybe drug testing and all kinds of different things. And then they also might be part of the HIPAA designated staff and also receiving PHI. So that person will need to know what hat they're wearing. Who are they acting for in that particular function? The health plan, the plan sponsor receiving PHI for the health plan, from the health plan and their HIPAA designated staff function, or on behalf of the employer in its employer capacity. So another example, HIPAA designated staff Henrietta has been reviewing a list of participants in the diabetes wellness program offered by the TAC health plan for permitted HIPAA purpose. So far, so good. She's HIPAA designated and she knows she's working on behalf of the health plan and it's for a permitted HIPAA purpose. So far, so good. Henrietta also has a meeting with an employee's manager who is upset that the employee has missed so much work. Henrietta thinks she has seen this employee's name somewhere before and realizes it's from the wellness program list. Can she fill the manager in that this employee may have a health issue? No. So Henrietta would need to consider what hat she's wearing. Any information she knows when she's working with PHI and has her HIPAA hat on, she can't disclose for a non-planned purpose and not for an employment purpose. Red flag number 4. Don't forget the subcontractors. So if a county or district will disclose PHI to an agent or a subcontractor, it has to require those agents or subcontractors to agree to the same terms in the plan sponsor certification. So we talked through that when I listed all the different requirements for the plan sponsor certification. So most groups I talk to say, no, we're good. We have our HIPAA designated staff, only a few people. They knew who they are. We make sure everything stays within them. So we don't have, we are very clear. Nothing can go to anyone outside of the HIPAA designated staff. But sometimes they forget to look behind the scenes and see who else might have access to that PHI. Sometimes we outsource copy room, IT services. We might have some independent contractors or consultants who also might have access to that PHI, helping us troubleshoot or to make copies or reports. So somebody else actually might have access to that PHI, but maybe it's not someone we were thinking about, some other vendor. If that's the case, then that is a subcontractor who is accessing PHI, and under our plan sponsor certification, we're required to make sure that they also agree to those same terms. And when I advise plan sponsors, I tell them you should have that in writing, similar to a business associate agreement. You have, as a plan sponsor, a whole list of things that you've just promised in your plan sponsor certification. And one of them is to make sure that subcontractors agree to the same terms. So I would copy all those same terms and requirements from the plan sponsor certification and tell the subcontractors or agents, this is what we expect of you. I would have them sign that in writing. So you have some assurance that they also are going to comply with HIPAA. Or you want to be very careful that you're only disclosing PHI to that small group and not using any subcontractors. All right, red flag number 5. Oh no, what if we have a breach? So when I talked about the plan sponsor certification, I said that one of the requirements is that if we have a privacy violation, if we have a security incident, then we're required to notify the health plan. That's one of the requirements of the plan sponsor certification. So if we have a breach ourselves, we probably have all kinds of procedures that we have to follow as a county or a district, probably some mandated by state law, maybe our own procedures that we have to notify probably the county district attorney, maybe to notify your own legal counsel, all kinds of reporting requirements you already have. But now you also have this PHI. If you've gotten PHI through the plan sponsor certification, now HIPAA applies to that information as well. So if we have a breach and that breach includes any of the PHI, and sometimes if it's a kind of general hacking breach, it might be of the whole system, and that system might include some PHI, then we have this responsibility to notify the health plan. So first of all, we're going to want to understand if there is some type of breach, what happened, what information was involved, and in particular, if that involved PHI, because then we have these extra HIPAA duties. So if we notify the TAC health plan, then the TAC health plan has to go through those steps that I talked about on the breach slide. They have to gather the facts. They have to review everything to see what happened. Do we think when we apply those factors that PHI has been compromised? And if the TAC health plan thinks it has, then the TAC health plan has a requirement to notify individuals, in some cases the media, and the United States Department of Health and Human Services. And the health plan has timeframes, deadlines it has to work within. And those deadlines apply when anyone in the organization, in the health plan organization, knows about the breach. So we want to make sure if we have a breach and it has PHI involved, or even if we're not sure it has PHI, but it could, then we're going to want to coordinate with the TAC health plan right away. So we can coordinate together, make sure they have what they need, the health plan, in order to make notifications. They have to document any breach. HHS will request a copy of that documentation if it looks into it. So we want to make sure that we're thinking through if we have a breach, it could involve PHI and what we need to do. Also, a good idea to notify your own county or district attorney or legal counsel, because you probably, like I said, have your own internal procedures as well to handle a breach. All right, so we have gone through a lot. We have gone through the HIPAA box, what entities are in the HIPAA box, the covered entity, the health plan, business associates, what is PHI, what is the identified information, and how information can be used and disclosed outside the HIPAA box. We've also gone through, if we're a county or a district, a plan sponsor of health plan, the TAC health plan for our own employees, and are requesting PHI from the TAC health plan, what that means. We can only get that information if the individual signed a HIPAA authorization or we've signed the plan sponsor certification. And we've gone through the requirements of the plan sponsor certification, plus my 5 red flags. And I said at the beginning, if you only remember one thing from today, what would it be? If all else fails, remember your HIPAA hat. Be able to recognize when you receive PHI so that you can put on your HIPAA hat. Only disclose PHI for a health plan purpose. PHI should not be disclosed for other county or district purposes or employment purposes. If you perform multiple functions and you're someone who wears your HIPAA hat, know when to have your HIPAA hat on and when to take it off, such as when performing functions for the county or the district as an employer. And you need a firewall PHI from non-PHI and only share PHI with those who also wear HIPAA hats. So if you only remember one thing from today, remember the HIPAA hat. If you're part of the HIPAA designated workforce, then you have your HIPAA hat on. So you have these extra responsibilities and you want to make sure you recognize PHI, only use and disclose it for a permitted purpose. Make sure you know for yourself, do you have your HIPAA hat on today for that function or not? Because you can only use PHI for HIPAA purposes or for health plan purposes, and not to commingle the PHI with the non-PHI. So thank you for attending HIPAA Basics. Have a good afternoon.